It is 10:05. Hello, good morning to you. Steve Martin here on ABC Radio-Melbourne, and it is that time of the week when we talk about the law. And with me in the studio is David Whiting, Melbourne solicitor. David, good morning to you.
Good morning, Steve.
As always, you are here, and you are here to take listeners' calls, so we'll give them the number to get them started, which is 1300 222 774. 1300 222 774. And for text, of course, for David, 0437 774 774. Lines are open right now. And, of course, the SMS is always there for people to contribute.
Subject to the warning. If I ask you a question as a result of what somebody sends in by text message, where do we go?
Okay.
Okay.
All right. The warning.
That is the warning, yeah.
Yes.
Now, what I wanted to talk to very briefly is that there's a land tax regime that basically is designed to encourage people to keep residential properties occupied by people. Mm-hmm. So homes in inner and middle Melbourne unoccupied for more than 6 months in a calendar year may be subject to a vacant residential land tax. And each landowner has an obligation to notify land tax of unoccupied homes.
Okay.
So there are a very large number of overseas investors who own property and they keep it vacant. It's
they're doing this really just for the investment value and hoping the property goes open. Yeah.
One hopes. Mm-hmm. So there's lots of those. Think of holiday homes. There are exemptions for holiday homes, city apartments or homes used for work purposes. So you might choose to live in Mildura and come to Melbourne 4 times a year or whatever it is. Properties transferred during the previous year, so you don't meet the 12-month proposition. Mm-hmm. New residential properties. But to get the holiday home exemption, you need to use the property. It actually needs to be used by the owner for at least 4 weeks. So you've got a holiday property down at somewhere on the coast, and you allow everybody uses it but you in the course of a year, you have to pay the land tax. So the land tax is an extra 1% on the capital improved value of the property.
Okay.
So I have no idea how much the government anticipates they will make, but I imagine they think it will be substantial.
It's self-reporting?
It is self-reporting. There are penalties for not reporting, but it is a self-reporting process.
Okay.
And you know what it's like, because once you're in the system, you're in the system.
Indeed. All right. Just because of previous personal circumstances, I can imagine a situation. I had a house that required some renovations.
Yes.
Was some distance away.
Yep.
It was unoccupied.
Yes.
Technically, I suppose, for 6 months.
Yep.
And I was there whenever the weekends allowed. Power was on in my name. All the things were back on in my name so I could complete the work that needed to be done. Is that classed as unoccupied, or is that...
Well, you would need to add, if you were there for 4 weeks, not continuously, but if you're an aggregate there of 28 days over the 12-month period, you're okay?
You'd be okay?
Yes.
Okay. So if you're in and out...
So, you've got the sleeping bag because you've got no furniture there, that still counts.
Yes, right? I did, actually.
Yeah.
So as long as you're there for that 28 days over the period...
Where do I send the bill, Steve?
All right.
Okay.
All right. Send it to the ABC.
All right.
See what response you get with all of that.
Now,
right.
I had some homework.
Yes, indeed.
I had Margaret, who was in a retirement village, and the question that she had was there were rabbits coming from a building site across the road, and she was worried about the rabbits and they were eating her plants, and she wanted to go to the retirement village manager to get the manager to do something about it, and the manager would not do anything about it and said, well, people's pets might die if we put out bait for the rabbits. Well, I can tell you that the Catchment and Land Protection Act says that in relation to his or her land, a landowner must take all reasonable steps to prevent the spread of and, as far as possible, eradicate established pest animals. A rabbit is a pest animal for the purposes of the Catchment and Land Protection Act. So you would simply go to the landowner, to the village, and you would simply say, I need you to...
control your rabbits.
Control your rabbits. Control the rabbits, which have become established in our property. Please do something about it.
And they are legally obliged to do that.
They have an obligation under the Act, but remember, it's the government which enforces it. What might Margaret's issue interesting was that there were 200 residents in the village, and at the time she'd spoken to us, 6 people had made the complaint. So it was almost, from Margaret's point of view, 6 saying the other 194 need to step in line. The suggestion was that she puts together a petition and gets a lot more people than 6 to sign it.
Okay.
All right.
So there's the homework. Now, questions going back to the land tax.
Yes.
Says, I thought David said houses in Melbourne and inner Melbourne, but then mentions coastal.
No,
Can he explain?
No, okay. Well, the answer would be no, it's not. Surf Coast and Mornington Peninsula are not. It's Melbourne and inner Melbourne. There are 12 municipalities. The SRO website, sro.vic.gov.au, will give you a list of the relevant municipalities.
Okay, so a home in Bendigo on another SMS that's been vacant for 7 years, unaffected. Unaffected, all right. 1300 222 774 is the number, 1300 222 774. And for texts, 0437 774 774. There's a couple of text message questions that have come in, but Mary in Baldwin has called. Hello, Mary.
Hi.
Mary.
So basically I wanted to understand a little bit about spousal maintenance and on what grounds a partner or a mother would be entitled to that because she's staying at home with the children versus the other party's request for the individual to go back to work.
The expectation is that, it's possible to get temporary spousal maintenance, but it's very rare to get long-term spousal maintenance because the expectation is that you will maintain yourself, and that's distinct. Child support is different, and you will be provided with financial resources in terms of child support depending upon the relative incomes of the two of you. But there are an extraordinary number of people who juggle full or part-time work with childcare.
Right.
So there's an expectation that where possible, you will get some form of employment, and so that's, broadly speaking, the way it works, Mary. It's based on need. If you had triplets under 2, well, then the argument might well be that, okay,
you need to stay at home and look after the kids.
And therefore for a period of time, then we'll give you something. But the general proposition is that it's not like the old model of alimony that went on forever, and that we see in the States as being quite frequent. The expectation is that sooner rather than later you will assume responsibility for your own financial maintenance, and that again is distinguished from the distribution of capital assets on the breakdown of the marriage.
Okay. Hopefully that helps, Mary, with your question. On the SMS, and I should just say, though, there's a fair bit of space on the talkback lines this morning. So 1300 222 774 if you want to talk to David Whiting, our Melbourne solicitor, who's here to take your calls as well. We've got a few SMSs to work through, but it's always nice to be able to talk to people directly. So 1300 222 774. The phone line is better for those follow-up questions, of course, that are needed sometimes. Question, I love this as a topic. The nature strip grass out the front is owned by the council. I'm required to mow it. I believe if I don't, I get fined. So if I mow it and my mower throws up a rock that hits someone or a car, who's responsible? Me or the council that owns the land?
There are a series of steps in that, right? The first one is that I don't see that the Local Government Act gives the councils the right to impose an obligation on you to look after someone else's property. Now, I do know that there are a series of local laws that says you're responsible for my property, for council's property. And I look at, on my reading of the Local Government Act, they don't have that power. All right?
Okay.
So, but whether they do or they don't, if you mow the lawn or the grass, generally grass on a nature strip rather than lawn, and you have an obligation to do it appropriately and safely. So you're responsible for the rocks that fly out of your mower. So rock hit car, your problem.
Right.
Should you mow the lawn? It's a different issue, and it's something that somebody one day will take to a magistrate's court and say that the argument they will run will be is that council can make rules as to how you use property. So they make rules in relation to how local parks are used, and that's all okay.
Yeah.
But I don't know that they would actually have the right to require an individual to maintain council property, which is essentially what the provision is.
All right. can you send them a bill for the lawn mowing time? Let's say I mow my nature strip out the front. If it's council land and they're insisting I maintain it, can I then send council a bill for fuel and time?
Along with my bill to the ABC.
Yeah,
same likelihood of being paid. I think. The answer would be no. I mean, their argument will be you have an obligation to do it. Then the question is, well, what rate? There's a whole series of questions, but I would come along. I don't think they've got the obligation to make you maintain your nature strip. Although, just up the road from me, there's a man who's got this mammoth garden on his nature strip. And
that's frowned upon in some areas.
Oh, yeah.
Regardless of how magnificent they can be.
Oh, this is just extraordinary. Yeah. He doesn't water it. There are lots of desert-type plants on it, but it's very impressive.
All right. Faye is in Armidale and is with us. Hello, Faye.
Hello, Faye.
Hello, Faye.
Oh, hello.
Quick, Faye, come to the phone.
Oh, yes.
You're a very long way away.
Sorry to bother you. Now, this is an unusual one. This is about what's called a homestay situation.
Yes.
And, I'm just a mum at home and I have 3 rooms that I let out to international students.
Yes.
For food and lodging and board and all that. I've been doing it for many, many years. Now, recently, we used to go to agencies and all sorts of places, but now I go to a particular website. And to protect myself from, what they say, once you go into an agreement, it's entirely up to you. There's no one to protect you.
No one to protect the student either, really, though, Faye.
No, that's right.
Yes.
But they go on the website. They usually have family or relatives here or somebody like that, and they get a lot of host families to check out online.
Yep.
So they're not just checking me out, they're checking out a lot for the price and value and all the rest of it. Anyway, I recently had, I don't know if I should say which country they're from.
I don't think it makes a difference, does it?
You had a student leave though, Faye, is that right?
Yeah, I had a student come in and she told me online and in her email that she wanted to stay for about a year, and I said that's really good because I do prefer to have long
stay rather than short stay, yes.
Yeah. And she sent me many emails and said, I'm really happy. I said, how long would you like to stay? And she said, about a year or as long as you'll have me. So with that, I then gave her my requirements of the bond and the amount that she had to pay. She was very happy.
So what was your bond requirement and your notice requirement, Faye, in terms of weeks? So how many weeks was your bond? So it was a month?
Yeah.
And how much was the...
actually, when they arrive, I've got an agreement that I've typed up that says they've got to give me 2 months' notice prior to vacating, from the last rent.
Yes.
That's all. That's. They've
sorry. So they can't stay there during the notice period?
Yeah. They stay, and I give them their bond back if they've given me 2 months' notice.
Okay. At the end of the 2-month notice period, provided they've left?
Yeah.
Yes. Okay.
Everything, and they always pay monthly.
Yep.
And I haven't had a problem with that so far. I've just recently had a girl come. I mean, her uncle was here who checked out my house. He said,
What's the issue, Faye?
She left within 4 days.
Yes.
Claiming all sorts of weird things.
Yes.
I think they must have been there before or done it up. It sounded very strange to me. And she didn't give me the notice. And I said, look, I've signed the agreement.
No, Faye.
Yeah.
What's the problem? Don't tell me how you got there.
Bond,
yes.
And she's said, if you don't give it back to me, I'm going to take it to the Residential Tenancies Board. So I looked online, and there's nothing specific there.
I don't think you're covered by residential, and that's because the period of occupancies would be less than 12 months. She could take you to
claim there.
Yes.
And they said that we have to agree between us, and if we can't agree, it goes to VCAT.
Yes.
So that's where I'm at the moment.
It would be at VCAT whether it was considered to be a residential tenancy dispute, which I don't think it is, or a contract dispute. And the questions that need to be worked out, Faye, is whether what you've done, have you replaced the person in the room?
No, because there's certain times of the year
when it's hard. So you won't get anybody today. I understand that.
No, and
so
that's why I
Faye,
do it for the timing.
Faye, the question will be whether the clause that you've included in the contract is a penalty or not. All right? So I understand why you've put it in there to protect your flow of income.
Yeah.
Particularly in circumstances where you're not able to find somebody. So if the matter was to go to VCAT, the question would be, what steps did Faye take to in fact find a replacement student to occupy the room?
Yes.
And I presume that would be immediately she left, I relisted the room on the website that she came to me from. Yes. And since then I've had this many people come through, but nobody wants the bed till February. And so you're really going, you will go to VCAT, unless you give it all back, would be my expectation. Yep. But I would have thought, let's assume that somebody leaves and 2 weeks later you find somebody new who moves in. Yep. Then I would be inclined to say you're entitled to an amount, not a huge amount, for the inconvenience of reletting and re-advertising and all the rest of it. And in addition to that, but apart from that, you would logically give them back the money that might be applied to the period when you had somebody in there. So let's assume she leaves without notice, but it tells you she's not coming back. Yep. 2 weeks later, you find somebody new who starts paying you the bond and the rent.
Right. Logically,
you're out of pocket for, if I ignore what she might have paid, you're out of pocket for 2 weeks.
Yep.
And you might then come along and say there'll be, sometimes what some trades would call a restocking fee, you might call it a reletting fee.
Yes.
So I want you to compensate me for the period that I'm out of pocket because you didn't honour your side of the deal.
Yeah.
All right? And that may not be 2 months, but it might be 2 months. So I would be looking at reviewing your agreement that says if you leave, then your maximum liability, then you're liable to pay a reletting fee, and you're liable to pay for the period between when the room is vacant, but no more than 2 months.
Yeah, well, whether it's reletting or the words are...
Well, a redocumenting fee or, or a re-advertising fee.
Isn't it? Because the times of the year are usually twice in the year that people come.
Yep.
But I've got in writing...
I understand what you've got in writing. The question is whether that...
The tenancy board have asked me to put the bond back with them, which I have.
Well, I don't know that... again, it depends on whether it's a residential tenancy or not.
Well, I've looked under there, all the clauses. There's nothing that covers it, but they have asked me to give the bond back.
Well, have a look. Well, then it will be the same issue at VCAT. All right.
So essentially, Faye, it looks like if this is pursued that way, you're going to VCAT.
If you're not prepared to do a deal, then it's back to VCAT. If you want to enforce the terms of the contract, then, and I was on her side, I might choose to run the argument on the basis that prima facie 2 months is an unreasonable period of time. And it might be unreasonable in late December. It might be unreasonable in February when people are looking to come to start college, but it might be unreasonable in December. Yep.
There was no one else.
No, I understand.
Her
okay. I'm not the umpire though, Faye. It's off to VCAT.
Yeah, I think that's where we might have to leave that one, Faye. But thank you for your call, and it does sound like it will probably end up at VCAT. Jennifer from Glen Iris, I think with a relatively quick question. Jennifer, good morning.
Good morning. I'm ringing about the vacant house issue that you raised earlier.
Yes.
In our area, we have a house that was sold in March 2016, so over 18 months.
Yes.
People started building work shortly after. They've never lived there. The work is still going on periodically. Someone will come and do a bit and then disappear, and the place looks like a dump. Or, the garden, they've dumped rubbish from another site there and all sorts of things. And I'm just wondering how long or what other action we should take.
All right. I don't know, Jennifer. I will, however, let you know next week. The issue from my point of view would be there are a series of exemptions, and it might well be that a house is being constructed where, there's a building contract and work's being done within a particular time frame, may not count as residential premises for the purposes of this land tax.
Yep.
It counts as for the purpose of normal land tax, but perhaps not for this one.
If work is going on, even if it is sporadic, all right. So a bit of homework for next week for that. Thanks,
Thank
Jennifer.
You, Jennifer.
Beverly's also called in Brimley. Hi, Beverly.
Good morning. Steve, and also David. Look, my query is about an application for probate. My father died August 19. The will was redone 2004 after my mother's death. It was done at a law firm in the city with witnesses there. The new solicitor that we have engaged to do the application is procrastinating. He said that he had to find the two witnesses and speak to them, and I still have not signed as executor.
You're the executor, Beverly?
Yes, I'm one of the three.
So there are three executors. Are you all of the same view?
Yes, it's my brother and sister.
So what you do then, Beverly, is you have to remember that you're the client. You're in charge.
Well, you'd like to think that.
I have clients who think the same way. They're not always right, but never mind. But Beverly, what you do is it's up to you to find the witnesses. Sorry, that's not even right. The clause in the affidavit that you sign says the will was witnessed by A of address whatever it is and B of address whatever it is, right? That's it. Now, why don't you go back to the law firm and ask?
The people have moved on. He's found one of them. The other person isn't responding.
Then your answer is cannot be located. So you might choose to say that they were, the will was executed in the presence of both formerly employees at the law firm such and such, and I've located X at this address and I can't locate B. Mm-hmm. And that fulfills your obligations. That will get you past the probate office, which is all you need to do. Now, look, there was a time when you used to get will witnesses who you'd use a police officer or you'd use a bank manager or, someone who was likely to continue to have the same name and always be trackable. Mm-hmm. Now, and every now and then you'll find a will where the witnesses were two young female law clerks who've perhaps got married and have changed their names and moved on. And so, the law... That's the clause in the draft affidavit, but you alter it to accommodate your circumstances. Mm-hmm. So push the issue. He's not required to interview them. On a prima facie basis, the document stands as it is. Right. If he thinks it's wrong, he should tell you why he thinks it's wrong, or she, for that matter. Yep.
All right. I'm just worried that every time I make contact, it's costing us more money. But you're right. I need to. I'll phone him again today.
All right. Well, no. What you would do is that you would, I'd be inclined to send him an email that says, I've discussed this with my brother and sister. We don't want you to make any further inquiries for the witnesses, and we want you to include in the affidavit the searches you've undertaken. All right?
Okay. All right. Thanks, Beverly. Beverly at Brimley. Anthony at Narre Warren is on. Let me just grab Anthony's line. Hello, Anthony.
Yeah, g'day, Stephen. G'day, David. This is a family law sort of question. Now, I don't know how to go about this, and it's extremely emotional. But I've been sick for a very long while and been forced out of home. Now I'm being told that my home is no longer going to be mine. It's going to be my spouse's because she has 4 children to look after, which I understand, and I feel extremely guilty about being put in this situation or putting them in this situation. I'm too sick to work. I'm on a DSP. And you go to court and you think, well, they'll be reasonable about this. They'll understand how unwell I've been, how long I've been out of work. But then it just seems to know, we'll just go off to the court registrar, and they don't know from a bar of soap, and they come back with a figure something like 75-25 in her favour. And you think, well, geez, that's pretty unjust in my eyes. After working for 30 years and trying to put a roof over their head, I've got all my superannuation's been put into the house to keep them housed.
Anthony, if you lose your interest in your house, you're losing it because of the breakdown in the marriage, not because of an undiagnosed cancer. So don't link the two. That's not the cause and effect.
Well, it is.
Sorry.
I was sick from 1990.
No, that may well be true, and that may be the cause of the breakdown of the marriage, but it's the breakdown of the marriage that is causing the division of the matrimonial assets. And what happens is that in theory is you deduct from the pool what you brought in. You assume that what's been generated in the time you were together is property that's to be divided between you. But if your former partner is the custodial parent of 4 children, then I would have expected a significant skewing of the total asset pool in her favour.
Simply because she has to maintain the children and the ability to do that.
Well, they will be living with her. Yep.
So hence the 75-25.
And also, in the skewing, I would have thought, Anthony, would have been even greater because you don't have any ability to provide income support to your children. I understand why. I really do. But when you're dividing the asset pool, there are 4 children that need to be looked after as part of this.
Yeah. So in terms of Anthony's other question, should he get another lawyer? It doesn't sound like, from what you're saying, this is the way it is, the way it's sort of fallen for him. So,
you might move it a couple of percent one way or the other, but I can't see that you're going to get 50-50.
A major difference,
No.
right. Peter at Oakley South, good morning.
Yeah, g'day, gentlemen. I've got a question about a commercial leasing arrangement. We've just basically signed a lease for commercial property. We're 3 months into the lease, and there are some building defects that are adversely affecting our business, namely the roof leaks whenever there's heavy rain.
Yes.
And we've since discovered from the previous tenant that this had been an ongoing issue since January when the building was commissioned.
Yes.
And apparently the previous tenant hadn't paid rent for about a period of 6 months because of the leaky roof. Now we find ourselves in a situation where we're trying to run a childcare centre.
Yep.
It's a 2-storey building, which basically means that...
So you've got the ground floor, have you?
No, we've got the entire building, so
Yes.
we've leased the entire building.
Yep.
But because of the leaks and a few other occupational health and safety maintenance issues, namely the glass balustrade in the play area got cracked glass in it, et cetera, we've been unable to use the first floor. And so we negotiated...
Well, let's stop for the moment. In
Sure.
terms of the glass balustrade, was
Yep.
was that its condition at the time you took it over?
Yes, when we inspected the building it was, but we were assured by the owner and his agent that would be rectified when we took over the lease.
Yep. And in terms of and you weren't told anything about the leakage?
No, we found out...
Peter, you've got to go and look at the lease.
Yep.
And the particular words will be important. The representations made will be important. You have the right, is a dispute between a landlord and tenant in what's a retail lease, because the retail provision of services, the childcare, and you have the right to go to the Small Business Commissioner, and if you want to take on the landlord, you've got to start there first. Small Business Commissioner, if you don't resolve at the Small Business Commissioner mediation service, you then go off to VCAT on the basis that you've got a dispute, and VCAT is likely to order the repair of those items.
But it's a long road to get to that order, by the sound of it. That can take some time from what you've just described.
Well, I thought you would have the mediation over within a month and then off to VCAT.
All right. We're going to have to leave it there. David, good to see you. Thank you very much for your time. That is David Whiting, Melbourne solicitor, and he joins us on the program for some legal talk back on a Tuesday morning.